Joining us to discuss that structure and regulatory issues around it is Jonathan Kanter. Of course, he's the former Assistant Attorney General for Antitrust at the DOJ, also a CNBC contributor. And Jonathan, I really wanted to get your take on this because I was reporting it out on Wednesday, and it was hard to sort of navigate it in terms of what are they actually acquiring, how are they doing it, and why are they designing it this way? It's an innocuous headline, right? A non-exclusive licensing agreement doesn't seem to be particularly significant, and yet Nvidia is paying an enormous amount of money for this. As an antitrust regulator, how do you view these deals? Because this is not in isolation. We've seen similar deals from Nvidia in the past, from Meta for Scale AI and others. Do you think they are designed to sort of avoid scrutiny from the regulatory side?
Well, if they are, then that's a problem. So there's a legal doctrine in antitrust called an avoidance device. An avoidance device means if a company structures a transaction in order to avoid a mandatory notification form under the Hart-Scott-Rodino Act, an antitrust notification, then that itself is illegal. And so to the extent that the parties design the transaction using non-exclusive licenses and reverse acqui-hires and the whole list of significant but quote-unquote non-significant events, then that itself can raise antitrust scrutiny for violating the process of filing with the agencies. And so that's a concern. And then on top of that, agencies do have to make sure that this doesn't become the standard practice as a way to circumvent their review. And so it certainly caught my eye, and it caught the eye, I'm sure, of many others in the antitrust community.
Yeah, so I'm curious as to how you think about it then, this particular deal or others like it. I mean, we're licensing their key technology, not exclusively. And by the way, we're taking virtually all their important employees. But it's not an acquisition. I don't know. I'm just curious, like how if you were sitting in your old chair at the DOJ, how you'd be thinking about it.
Well, here's what I would tell my team, which is if it looks like a duck and quacks like a duck, then it ain't a pig. And in this instance, they're getting the key employees, they're getting access to the technology. It's a direct competitor, and they're paying an arm and a leg. That looks and sounds a lot like an acquisition. And so I would instruct the team to make sure that they're investigating the transaction and its competitive consequences as if it were an acquisition, because that's what the antitrust laws are there to do. If there's a problem, then they need to intervene. If there's no problem, they can stand aside and let the deal go through.
Right. We should point out we haven't gotten a lot of detail around the deal itself from Nvidia at all, other than an internal memo from Jensen just announcing the arrival of some of these key hires. They're not a full-stack competitor, Groq, in any way to Nvidia, but they are seen as perhaps helping the overall GPUs in terms of their particular expertise called the LPU. I don't know how much you know about it, Jonathan, or care to discuss it. I would assume regulators need to be taking a close look, though, in terms of whether there really is a competitive aspect to it.
Well, that's exactly right. I mean, this is typically how competition presents itself in technology markets. It may not be that a competitive threat is a full stack competitor, but here you have training, which Nvidia does better than anybody, and it's extremely expensive, and their chips are really hard to get. They take a long time to get, and they consume a ton of energy. Then you have inference, which is when you use the chips. And that's where Groq really has figured out a way to do it faster, cheaper, and with consuming a lot less energy, and a much shorter wait time to get the chip. And so it is competing for certain workloads and for inference against NVIDIA. And in that sense, one could at least question whether Groq has emerged as a threat to the moat that protects NVIDIA. And so by doing this deal, one of the questions you want to ask as an enforcer, not only is NVIDIA acquiring the technology and the employees of a direct competitor, but is it weakening somebody who, left to their own devices, would have grown in size and significance to take more business away from NVIDIA?